Welcome to our debate on tort reform. I want to introduce our two distinguished debaters, and then we will get underway. The question being debated is tort reform as defined in SJR 8, which I will read in a moment, a conservative issue. Dan Greenberg will be for the affirmative, correct? As far as I know. And Joy McCutchen will be speaking against this particular joint resolution. Dan is the president of the Advanced Arkansas Institute. He's a lawyer, a former adjunct professor of law and political science at UALR, and the former senior counsel for the Center for Class Action Fairness, an organization which protects the public from abuses in illegal class action settlements. He served as a legislator representing parts of Pulaski and Saline County from 2007 to 2010. Before that, he represented the western part of Pulaski County as a quorum court member. As a state legislator, he received the Arkansas Press Association's Freedom of Information Award for his work on First Amendment issues. Joy McCutchen serves as the president of the Arkansas Trial Lawyers Association. He's been a member of ATLA for over 20 years and has served on the ATLA Board of Governors since 2003. He received the ATLA's 2013 Citizen Merit Award, which is given to the attorney who seeks to foster greater public understanding of the rights and liberties that ATLA seeks to preserve. He's the founder of the Transparency in Government Group of Western Arkansas, which was established in 2015. They are advocates for transparency in government entities, and they provide educational seminars with keynote speakers to advance that. He is also the founder of the Arkansas Consumer Advocate and enjoys teaching and lecturing on U.S. and state constitutions. He wears the 7 pin symbolizing the importance of the 7th Amendment. Please join me in welcoming both these gentlemen. Okay, the question being debated is tort reform as defined in SJR 8 conservative. And I'll give you a brief overview of SJR 8. Senate Joint Resolution proposing an amendment to the Arkansas Constitution to limit attorneys' contingency fees in civil actions to 33 1/3% of the net recovery, to limit awards of punitive damages and non-economic damages in civil actions, to require adjustments to the limitations of punitive and non-economic damage awards for inflation or deflation, and to provide that the General Assembly may, by a 3/5 vote of each House, amend or repeal a rule of pleading, practice, or procedure prescribed by the Supreme Court and adopt a rule of pleading, practice, or procedure. Okay? The debaters are going to debate the issues stated above and what I will call the traditional method. Each debater will articulate his position to the audience. The debate is intended to allow the debaters to argue a position for and against during one's allotted time. Each debater is allotted a specified period of time to present. At the end of the debate and prior to closing statements, there will be a time period for questions from the audience, so be prepared for that. The debaters will present his position to the audience without use of document, props, third parties, etc. You're here to debate the question and only the question, nothing more, nothing less. These guys are both very skilled debaters and familiar with the rules of the court, and those will be the order of the day. We're going to split the debate up into 8 5-minute segments. Debaters will speak during alternate segments. Each side will get 4 5-minute periods. The debater speaking in the affirmative will go first. We have a moderator with a time clock. Will direct the speaker to stop when the 5-minute segment time is elapsed, and actually there's a minute warning. And thank you, Bob Gregory, for being our timekeeper. Following the third segment of the debate, we will open it up for 10 minutes for questions from the audience, and both debaters will get to respond to the questions for 30 seconds. At the end of the debate, you will vote on who won the debate. So that's what we're doing today. And so without further ado, I would like to offer or invite Dan Greenberg up for the first 5-minute segment.
Well, I'd like to thank all of you for coming. I'd like to thank the Tea Party for setting this up. I was a Tea Party person when the Tea Party wasn't cool. When the Tea Party had its first rally in front of the Capitol about 10 years ago, there was one state legislator who was invited to speak. That state legislator was me, and I think it was because of my record, standing up for individual freedom and the rule of law and limited government. Those are the kind of conservative values that I believe in, and those are the kind of conservative values that tort reform advances. My support for tort reform is an expression of Tea Party values. Now, I went to someone whose advice I value very much, and I asked him, tell me how I ought to handle this debate. Tell me what I ought to do in this debate. And he said, son, let me tell you, I want you to do something. I think you ought to consider this. You should do something that, to my memory, has never been done in an Arkansas political debate before. I think you ought to seriously consider treating your audience like adults. I think that there's something to that, and it's kind of half a joke, but it's half serious, because this is really kind of a complex question, and I think it's going to be easy to make snap decisions about it or have emotional reactions to it. But as far as I'm concerned, your job is to become the third person in the room. There's a lawyer here and there's a lawyer here. As you all know, whenever two lawyers get together and argue, there's often a third person in the room, the judge. And the judge is really supposed to weigh everything and look at all the considerations, not make any snap judgments, but take a whole world perspective. And I ask you to be a fair-minded judge about this, because what I want to argue for, what I think I'm going to show you today, is that tort reform is going to be a huge advancement for the welfare of Arkansans. Today, I'm going to show that tort reform is going to make the people of Arkansas healthier and wealthier. I'm going to show that tort reform restores the balance of power in the Arkansas Constitution that was taken away about 10 or 15 years ago. And I'm going to show that tort reform sets the stage for real legal reforms that make Arkansans' life better. And the way I put it now, it almost sounds as if it's the most wonderful thing on earth. And so I guess I laid awake last night and I was worrying, what is Joey McCutchen going to say about tort reform? Because my instinct is he might differ. And here's what I think he's not going to say. I don't think he's going to say that tort reform destroys our 7th Amendment rights, because we all know that in half the states of the Union, we have the kind of tort reform that we're talking about today here in Arkansas, and 7th Amendment rights are still alive and well all across the nation. And he certainly can't say that tort reform harms health care, because we have states that have tort reform, and they provide some of the best health care in the nation. And here's what I worry that he's going to argue. I worry he's going to give you some sort of extreme, emotionally heart-tugging, one-person example. And I think that emotional examples are very powerful. But I ask you in all seriousness, please don't make a snap decision that's not based on the welfare of everyone in Arkansas or everyone in the nation, because we all know that every change in the law creates winners and losers. We all know that the reason we create a Constitution, and you can read it in the preamble, right? The reason we have a Constitution is to advance the general welfare of the people. And so those are kind of my introductory notes, but let's talk a little bit about what we know from experience, what we've seen in other states that have passed tort reform. Here's what happened in Texas. I want to talk a little bit about our experience, our knowledge, what happened in Texas. Texas, about 15 years ago, it passed a kind of cap, and it passed a number of tort reforms on regulation. And here's what happened in Texas 10 years after it passed tort reform. The number of doctors in the state of Texas nearly doubled. Think about that. Think about that kind of growth in availability of medical services. In that period, rates for malpractice insurance in Texas, they dropped by half. In the same period, let's take a look at another state. Let's compare two. In the same period in New York State, malpractice rates, malpractice costs increased by 50%. In fact, they increased so much that the New York legislature decided that it was going to have to subsidize doctors for their malpractice insurance the same way they subsidize farmers. There are lots of studies that show that damage reforms and tort reform makes healthcare expenditures drop. It makes healthcare insurance premiums drop. And I want to talk a little bit more after the break. I see that my 1 minute sign is up, but again, I'm thrilled to have all of you here. I know that it's a little cold in here. One of us today is going to do our best to fill the room with hot air, so you I thank you very much for your time, and I look forward to talking more about how tort reform is going to make us healthier and wealthier. Better off.
Good morning. Thomas Jefferson wrote in the Declaration of Independence that we are endowed by our Creator with certain unalienable rights. Among those are life, liberty, and the pursuit of happiness. Several years later, in our Arkansas Constitution, in the Bill of Rights, even before the preamble, the first section in our Constitution, Article 2, freedom and independence. All men have certain inherent and inalienable rights, among them those of enjoying and defending life and liberty. So we see, and I think that we can all agree in this room, what are Arkansas conservatives? I think the first fundamental of being an Arkansas conservative, which I have been all my life, is that we believe that life is sacred. We believe that life is valuable. And we believe that life should be protected at every stage, whether it's in the womb, whether it's a 5-year-old youngster, whether it's a stay-at-home mom, or whether it's somebody in a nursing home. That's our core belief, and our founders believed with all their hearts in that. Our Arkansas founders and the founders of our republic. SJR 8 would put a cap, would put an arbitrary, fixed, predetermined amount, a price tag, on the value of human life at $500,000. $500,000 for every Arkansan, in every type of situation, without a local jury, another conservative principle, a local jury listening to the facts, listening to all the evidence, listening to the wrongful conduct, and making the decision. Is it constitutional? I'm going to talk about the Constitution in a minute, because that's another bedrock principle of conservatives. I'm a constitutionalist. Sometimes I wonder what conservatives are trying to conserve, because sometimes it's not the Constitution. But I'm going to show you in a minute what SJR 8 will completely do away with in terms of our constitutional rights and our 7th Amendment rights. More importantly, our states' rights, Article 2, Section 7. But imagine, is SJR 8 immoral? I would argue that it's not immoral. Is it an immoral practice if this practice were applied, for example, to the death of a 5-year-old boy recently, Christopher Gardner, in West Memphis, Arkansas, who was in a daycare van, was left 9 hours in 90-degree heat and died? If that were your son or your daughter, is $500,000 enough? Or Randall Bull Randleman. These are real consequences of SJR 8. They're not emotional. They're just real consequences. Randall Bull Randleman. He was a World War II veteran, and he died in a nursing home in Texarkana, Arkansas. Imagine the government assigning an arbitrary value to those lives. Rose Mims of the Arkansas Right to Life, who many of you know in this room, has stated, "My first concern is the price tag that is placed upon the life of a person who is injured or killed due to the negligence of a nursing home." Jerry Cox, who is the conscience of the Christian conservatives at the legislature, has stated this: Anyone who is genuinely pro-life, that everyone's right to life is God-given, you can't put a price tag on a God-given right. There's a blip. He goes on to say there's a Kelley Blue Book value for used cars. There's an appraisal for the value of a house. There's even a place in the market price for cattle and hogs. But how much is a person's life worth? That's for juries to decide. That's why Rose Mims and Jerry Cox are against SJR 8.
Well, I want to say I agree with Joey on many of the things that he said. Of course we know we all have unalienable rights. Of course we know that life is sacred. And of course we know that life is extraordinarily valuable. But I do have concerns about one thing that Joey said, because I want to bring to your attention that there's one fellow in this room whose entire job, 40 hours a week, 60 hours a week, every day this fellow goes to his office and he puts a price tag on human life. This is what lawyers do when they go to court. The whole judicial process involves compensation. I don't know what putting a price tag on human life could be if it's not that. But for Mr. McCutchen to stand here and talk about how we're going to change things so that we're going to put a price tag on human life, this is what trial lawyers do. So I don't see how that is at all relevant, that accusation is at all relevant to this discussion. But I sure do agree that life is sacred, life is extraordinarily valuable, and we have to do everything we can to protect it. And that's why I was talking about the immense importance of advancing healthcare and making healthcare better in Arkansas. That's why I was talking about those statistics before. And if you value access to healthcare, if you think it's a good idea that Texas had double the number of doctors over 10 years, I think you have to be for tort reform, because that's a major conservative reform to get more access to health care to the people who need it. I mean, let's think about Arkansas. I love Arkansas, folks, but there's no denying that Arkansas has problems. If you look at, if you rank all the states, Arkansas is in the worst 1/5 of states. We're in the bottom 20% of doctors per person. We can do better than that. Arkansas is the worst 1/5. We're in the bottom 20% for cancer detection. Why is that? Well, I'll make a guess. I think it's because we don't have enough doctors here. We don't have enough access to health care. And the reason, in my opinion, one reason for this is that we have malpractice laws that scare doctors out. You ought to, I mean, if you were wondering about this, talk to a doctor. Ask him what it's like to practice here in Arkansas, where one mistake can ruin your life. One mistake can make you lose your license. It's not that way in other states. And I can testify from personal experience, being involved in a lawsuit, having to go through a deposition, having to have this hanging over your head for not hours, not days, but sometimes years. You know, just being a doctor who's almost a guest or who's almost a witness in an emergency room, you might be called and asked to participate in a deposition. Not called, it's not a voluntary thing. And so the threat of facing this kind of thing, it makes doctors, it's a very stressful life. It's highly stressful. Tort reform causes this because it's almost like a negative lottery, right? There's a chance every time you go into the operating room, every time you practice medicine, you could lose your license, you could lose your livelihood. This is why other doctors say, I'm not making this up, this is why other doctors say it's more satisfying, it's a happier experience, it's a better experience to practice law in other states. That's why there were so many doctors that fled from other states and went to Texas. The fact is, people don't come to Arkansas for top-tier health care. You want to know where's the best cancer treatment in the United States? What's the best facility? We know where it is. It's MD Anderson over in Texas. That's what U.S. News and Report said anyway. Now, also, there's a question of the effect that tort reform will have, not just on our health, but on our wealth. I mean, we all know that the American litigation system makes us beggars. We all know that it is imposing tremendous costs on us. My son, Robert, over there is wearing a wonderful button that says, "Cut spending and reduce taxes." Our lawsuit system is like something that places hundreds of dollars of taxes on every citizen of Arkansas every year. Over $100 billion came into Texas's economy once it passed tort reform every year. Texas created nearly 500,000 jobs after it passed tort reform. If you want to talk about the idea that tort reform advances economic growth, advances people's health, I say those are conservative values. I say that these are wonderful improvements. We'll talk about the constitutional changes that tort reform will create and how it restores the balance of power very shortly. But in terms of advancing people's welfare, the bedrock conservative value, I say you have to be for tort reform.
Patrick Henry stood up in March of 1775, and he knew that there was war coming. And he stood up and he said, "Give me liberty or give me death." He didn't say, "Give me jobs or give me death." It's about liberty. Ronald Reagan said, "If government's the answer, then you're asking the wrong question." Ladies and gentlemen, Google it. Preventable medical errors in hospitals are the third leading cause of death in the United States of America. Up to 440,000 people a year in our country die from medical mistakes every year in this country. Preventable medical errors. But let's talk about the constitutional argument. In Arkansas, we, as conservatives, we believe that we must protect citizen juries. And we have the 7th Amendment, which I wear a pin, because I went to the governor's office with Jan Morgan to defend the 2nd Amendment. But what we know is it's the 7th Amendment that protects all the rest. The 7th Amendment to the U.S. Constitution, which many people don't know about. And when you limit the amount of damages that a local jury listening to the facts of the case can hear, tell us what message does that send to doctors? But let's look at the Arkansas Constitution. And I ask that you go into the Arkansas Constitution and look at Article 2, Section 7. It says that the right to trial by jury shall remain inviolate. Is the right to trial by jury inviolate under Mr. Greenberg and his nursing home lobbyist proposal? That's
objectionable right there.
Is it inviolate? Is it left impaired when a jury can award whatever they want to after listening to the facts, and the judge, because of SJRA, says, "You're sorry, the legislature, big government in Little Rock, through overreach, is already said, sorry, it's $500,000 for your life, Mr. Nursing Home patient." But look, think about Article 5, Section 32 of our Constitution, which Mr. Greenberg would completely wipe out. Article 5, Section 32 was passed in 1874 in a constitutional convention. And the sentiment of the day was distrust of government, because this was after the Civil War. And railroads and legislators were running roughshod over the people. So under our Constitution, this provision, Article 5, Section 32, was put in our Constitution for days just like this. It says, no legislator can limit the amount of compensation paid for wrongful death or injuries to our person or our property. They knew that lobbyists, whether it was railroads in the day or nursing home lobbyists or their advocates at the nursing home or at the legislature, they knew that they needed more than just saying that the right to trial by jury shall remain inviolate. And they specifically put this provision in, that no legislature can limit damages. Because there are mechanisms. If there is a wayward jury out here who awards too much money, that's why we have the court system. Judges lower it, just like the judge lowered this nursing home verdict in Conway. Well, he was bribed to lower it, and he got he got disbarred. He was bribed to lower it, but Michael Morton and David Norsworthy, who Mr. Greenberg works with, the judge lowered that verdict from $5 million to $1 million. That's separation of powers. That's what we heard today by Mike Gallagher. We have this in place. We don't need the legislature putting this in our Constitution. We already have that procedure. That's a conservative philosophy. The balance of powers. That's a court's job, not a legislature. Remember, the legislature is the most political body. Think about all the laws that they're passing in Little Rock the last time. And think about who's behind it. It's big money. It's special interest elitists who are taking our rights away. And that's wrong. And as Thomas Jefferson said, as Patrick Henry said, when they get close to that jewel, we must fight for it. And that's where we are today. All based upon conservative principles.
Well, I too am in favor of liberty. And I want to talk a little bit about how we write liberty into our law code, how we write liberty into our Constitution. And I want to talk about how we protect the Seventh Amendment, which I assure you is as important to me as it is to anyone in this room. Let's talk a little bit about the fundamental safeguard of liberty. That is the constitutional balance of powers. Arkansas and Florida have very similar constitutions in this respect. Both of them say, according to recent interpretations of the Arkansas Constitution anyway, both of them say that the legislature cannot pass procedural rules. The legislature can only pass substantive rules. Let me tell you how this works. In Florida, a little while back, earlier this year, the legislature tried to pass a stand your ground law. It passed a special defense for people who are carrying a weapon. You all know what a stand your ground law is, right? Yeah. The legislature says you've got a right to a special pretrial hearing so that if you have a stand your ground defense, you don't have to go through the entire hearing. Instead, there's going to be a special procedure where you can make that defense, and if you win on that defense, then the trial's over. Well, the court struck this stand your ground law down. The court said, this is a procedure, the legislature can't do it. I want y'all to think about that. What that means is that the legislature doesn't have control of policy. Only the court has control of policy. We got the same problem here in Arkansas. That's something else that the SJRA is designed to solve. My opinion, I think every conservative opinion has to be that the legislature sets policy. The court can't set policy. And right now we've got a situation in Arkansas where the legislature can't pass tort reform. The legislature can't pass, one of the reasons I got involved in this, the legislature can't pass loser pays. The legislature can't pass a stand your ground procedure. And that's immoral, and it's wrong, and it's unconservative, because the legislature has to be the policy branch, and the court should decide cases and controversies. Now, limited government is driven by the idea of separation of powers. And just about everybody in this room believes in separation of powers and limited government, except for one person, because I think we all believe that the legislature ought to be limited, and the courts ought to be limited, and the executive ought to be limited. But apparently, there's one person in this room who thinks that there's one branch of government that shouldn't be limited, and that's the jury. I say that the jury is under the rule of law, and it's perfectly appropriate to require the jury to obey the law, just as it is to require all other branches of government to do so. That's a fundamental conservative value. That is limited government in action. And this whole idea that juries are not driven, juries should not be driven by the rule of law, I think is highly dangerous, and it's certainly unconservative. I do want to correct one thing. I think my associate here vastly understates the kind of damages that the kind of recovery that can be brought about. We all know that in the case of someone who is harmed, there's full recovery except for one tiny kind of damage, and the limit on that, if there are punitive damages, it's not $500,000, it's $2 million if there are punitive damages. And so I appreciate that we don't want to put a price tag on life, but it's hard to do that under our current legal system, because we all know that our current legal system places a price tag on life every day. There's no other way that you can do that. I mean, if someone's a wrongdoer, it's really not enough for the wrongdoer to come before someone else and say, I'm sorry, I shouldn't have done it. We compensate people with dollars. That's the way it works. And so I do want to say, I strongly support the Seventh Amendment. Everybody strongly supports the Seventh Amendment. And we got a right to trial. We got a right to a jury trial in every state. Every state in the United States, even though some of them have some kind of damage limits. And so this notion that we're somehow harming the Seventh Amendment with some kind of restrictions on jury actions or some kind of damage limits, it's just wrong. It's ahistorical. Everybody knows that you got a right to trial, you got a right to a jury trial, even when the jury has to follow the law. I strongly hope that you will consider looking at this thing again with an open mind, because again, tort reform is a measure that advances limited government values, it makes the health and the welfare of the people stronger, and it advances our freedom. Thank you very much for letting me speak to you today.
Mr. Greenberg says we still have a Seventh Amendment. Let's talk about just a second about the Second Amendment. Let's say that if the government, big government down at Little Rock, decided that they said you can have all the guns you want, but you can only have 200 bullets. We would still have the Second Amendment, like Jan was talking about, but it would not be a meaningful Second Amendment. What if the government down at Little Rock said, you can have all the free speech you want, but we're going to put a cap of 5,000 words on it? Because that's what they're doing in tort reform. They're saying, oh, you still have your right to trial by jury, but you see, it undermines the meaningful right to trial by jury. Mr. Greenberg mentioned punitive damages. He wants to put a cap on punitive damage. He in special interest. Are the people clamoring? Have you ever asked your legislator, have you ever gone to them and say, I really want tort reform? Tort reform just, no. I mean, tort reform is not something that people are clamoring for. It's special interest, it's nursing homes, and you know who it is that by limiting awards, you know who is the big profiteer? Insurance companies. You know what happened in California? When they passed tort reform, $250,000 limits. Look up California tort reform, first in the nation. They passed $250,000 limits on jury awards, took away local control. You know what happened over 13 years? Doctors' rates went up 450%. But after 13 years, you know what happened? It just flatlined. Doctors' rates stabilized. You know what happened in California? Maybe Mr. Greenberg should consider this. They passed insurance reform, Dan. And they said, insurance companies, we're not going to take away the rights of the people anymore, but we're going to make you justify why you're losing all this money and why you're not giving it back to our good doctors. And they just couldn't justify it. The bottom line is, this is important. Mr. Greenberg and the nursing home industry that he's working with, they don't trust people. They don't trust us. We allow our juries to put people to death every day. But Mr. Greenberg, because again it's about the money, follow the dollars. If a nursing home can get the predetermined result, what happens? They can sell their nursing homes for 10 times the value. And whose rights are they taking away? What would happen if we've got the equivalent in this country of 6 to 7 jumbo jets crashing every day due to medical malpractice? If that was happening, if jumbo jets were crashing in this country every day, do you think that we would take away the rights of the airline passengers? Or would we say, what's happening with our jets? You know, why are they crashing? We need to figure that out. But we've got to trust people. Conservatives trust people, not government. And this is a government solution. And I would say it's a solution to a problem that does not exist. And I want to talk about another conservative fundamental. It's accountability and responsibility. Because that's what juries do, right? They hold wrongdoers fully and fairly accountable. Yes, one side of it's compensation, But the other side of it is deterrence. They are the conscience of our community. They tell a wrongdoer how bad that conduct is by the size of their verdict. Now, Mr. Greenberg wants to cap punitive damages. I say let juries decide, but one of our core constitutional conservative beliefs is if you break it, you fix it. If you remember one thing, remember this. If tort reform passed, who pays? And who should pay? Vicki Jansen, a client of mine, was a vent-dependent quadriplegic for 10 years. If the wrongdoer, Ford and Firestone, did not pay, who do you think picks up the burden? Well, it couldn't be Vicki because she has no arms or she has no legs. It's the taxpayers. That's the secret that Mr. Greenberg does not want you to know. The taxpayer picks up the burden. That's why we want to get rid of Obamacare, because we're sick and tired of taking on the burden of folks who don't care for themselves. I mean, who should be responsible? Should it be the wrongdoer, or should it be the victim, the quadriplegic victim, or should it be the taxpayer? Because that's where it's headed, and we're going to be left holding the bag once again.
Okay, thank you. At this point, we're going to have questions from the audience, and each of these gentlemen will have 30 seconds to respond. Yes, ma'am.
How many attorneys left California when they passed tort reform?
Does anybody know the answer to that?
I can absolutely tell you that there's been a huge growth of lawyers in California since they passed tort reform. I couldn't give you the exact figure.
It's an interesting question. How many lawyers? I have no idea how many lawyers left California. But one thing that we do need to keep in mind is Mr. Greenberg. You heard him talk about how tort reform was not able to get out of the legislature in 2013 and 2015. Well, you know what was in that tort reform? It was limited strictly to medical malpractice cases. By the way, tort claims are only 0.1%, but
how many times does he go to the term limits?
Yes, sir.
Okay, so I consider myself generally pro-life. My wife and I are foster kids and we're adopting, and I think you would both agree that being pro-life is beyond just being for or against abortion. At that point, it goes beyond that. And so obviously valuing life is important. And so when you stated that the Right to Life and Family Council and other, generally pro-life groups are for this, and, placing an arbitrary value on human life would be in some way working against a pro-life agenda. Are we not, whether it's the legislature or Dan or a judge or a jury, are we not forcing everyone to participate in the anti-abortion? By that logic, are we not forcing everyone to place some arbitrary value on human life, because life is inherently valuable?
One of you wants to.
Is he going? I can answer it if you'd like.
Go ahead.
Well, I don't want. It's conservative values here. I don't want big government in Little Rock making arbitrary decisions about life, and that's the way that Rose Mims believes. She believes that that's just a price tag on human life, an arbitrary value. Now, our right to trial by jury, it may not be perfect, but it's the best that this world has ever known. And what I want is people who are listening.
I think that's a good statement in itself. So I think your question serves as a statement. So I'm not going to speak to that anymore. Okay.
I lost my husband last year because there were two doctors who were grossly negligent and incompetent. And before my husband died, we consulted an attorney. And on his deathbed, he told me to pursue it. We don't need tort reform because it already exists. I've already spoken to 3 different attorneys. They said unless I could prove 51% or more that these 2 doctors caused my husband's death, they wouldn't represent me. So my question is, if you put in this tort reform, which is no more than just a price tag on someone's life. How do you make doctors who are grossly negligent and incompetent responsible for what they did? Because you can complain to the Arkansas Medical Board, but it's controlled by doctors. Sorry.
Well, I'm sorry for your loss, and I lost my wife in March also, so I understand that not due to malpractice, so I understand some of what you're going through, but that's a fair question, because we as conservatives, we don't want regulation, okay? If we don't want regulation, then we only have two other options, and one of them is to get out on the street corner and have a shootout. That's accountability. The other one is the right to trial by jury. But you make a valid point. The medical society will only discipline a doctor for gross malpractice.
Time's up.
Not even ordinary negligence, and that is wrong. And until we have a system to fix the problem, we better not boot the jury trial.
I'm so sorry to hear about your husband. I think you and I have talked about your husband before. I guess I want to say with what's being considered here with SJRA, if someone acts with a bad purpose, there is no limit to damages. I don't think that tort reform changes what you call the quantum of proof. You asked about a proof question. I don't think tort reform affects that at all. But I can tell you, if someone acts with a bad purpose, such that they know something bad is going to happen, tort reform doesn't affect the damage limits at all.
Excuse me. I've been in the medical care industry for 52 years. I've never had a complaint filed against me. That certainly doesn't mean I've been perfect. I'm a pharmacist. But it means that I did graduate at the top of my class, and I did put a great deal of effort into doing the very best for every patient I encountered. First of all, I would like to advise everybody, choose your pharmacist as wisely as you choose your doctor.
What's your question?
Second of all, I would just be interested to know if Mr. McCutchen, assuming this is, I hope I said his name right, assuming that we didn't get any kind of tort reform, would he be willing to, because I will tell you, lawyers on the whole make a great deal more money than I ever did, but would they on the whole be willing to accept another regulation, whereas no matter what the case, no matter how much anybody makes, you don't get any more than 10%, maybe 12%, which I think would be vastly, vastly fair. And if so, it would take some of the hypocrisy out of what I see from the opposing position to Mr. Greenberg.
Well, and that's the bait and switch in this bill, because they know that folks don't like lawyers, and that's the American way, and we are regulated highly by the Supreme Court, but that's the American way. When we start fixing prices on lawyers, whether it's lawyers, if you don't like trial lawyers, when you start fixing prices, that's socialism 101, and that's wrong. That is not conservative. What's next with Mr. Greenberg? Are we going to regulate realtors? Are we going to regulate?
Well, I think you make a very good point. You know, one aspect of tort reform is the lawyer can't take more than 1/3 of the recovery. And generally, I think that's a good idea. It doesn't have anything to do with socialism. It has to do with what's called fiduciary responsibilities. It's outrageous that somebody could serve as your fiduciary and then pretend that it's some sort of arm's length transaction, the same kind of transaction you have with the guy you buy a burger from at McDonald's. A fiduciary relationship, you're not supposed to have this kind of bargaining business type relationship. You're supposed to act in the best interest of your client. And I think people who argue that that sort of thing is like socialism are really missing the boat.
Time's up.
Okay. Paul? So Joey, you mentioned that a judge should reduce an outrageous award by a jury. Do you believe that violates the Seventh Amendment?
Oh, yeah. Very good question.
I believe that what we've got is a system in place, and it's what we call separation of powers. That's the prerogative of a judge on multiple levels. But what we have here is we are having the legislative branch of government which is dominated by special interests trying to come in and regulate attorneys. Just like the McDonald's hot coffee case, there was a $2.9 million verdict. Now go look at the fake news, but the court reduced that to $650,000.
You make an excellent point. That's an excellent question because for the last couple of hundred years, we've had judges reduce the size of unconscionable verdicts. That's the way it's supposed to work, because sometimes juries get too inflamed by lawyers who appeal to emotion, not facts. Not that I'm thinking of anybody here. But it's very important to have a separation of powers where different parts of the government have to follow different rules. Every part of the government has to follow rules. And so reducing the size of verdicts by judges has everything to do, is completely consistent with the Seventh Amendment.
Okay, Mr. Pelley?
I just want to say that I used to be against tort. I used to be for tort reform, and then my sister that's younger than I is in assisted living, and we've had her in 4 different places, and they should be sued every day, and because of all the neglect. And nobody does it because of the situation. So we already have a situation where people don't file suit because there's all kinds of reasons they can bring back against them. So I think we have
Do you have a
that.
question for you?
Well, I was just going to ask him to, one of the things that Joey did once before, he explained the McDonald court case, and I realized that the media was trying to manipulate us like they do on everything else, and that was the deciding factor for me. That was before my sister was in the assisted living.
Well, some people would call that a frivolous lawsuit, and we all believe there's frivolous lawsuits. Does everyone in this room believe that? Well, maybe you should ask Mr. Greenberg why there's they want to limit meritorious lawsuits if there's a quadriplegic, if there's a death. Ask Mr. Greenberg, who drafted this legislation. He and the nursing home industry drafted it. Ask Mr. Greenberg why there's nothing.
That's just false. That's just false. That's just false. You agreed to debate the merits of this issue, and that's just false.
Ask Mr. Greenberg why there's absolutely nothing in this bill on frivolous lawsuits. We proposed, the trial lawyers proposed to punish the lawyers if there's a frivolous lawsuit. Punish the lawyers. Punish me. Don't take away the rights of the people.
Excuse me. Is there time to respond to the question?
Oh, did you? I'm sorry.
If we have time. So I appreciate that there are some people in the room who think that the more lawsuits we have, the better society we have. And I just want to say that according to the statistics, lawsuits, as a general matter, don't always make our societies better off. We're talking about nursing homes here, and I was reminded of the survey that was produced. They ranked all the lawsuits against nursing homes, and they found that poor quality nursing homes get sued 40% of the time every year. High quality nursing homes get sued 47% of the time every year. I may have that backwards, but there's little or no detectable statistical difference. In fact, everybody gets sued, and so it's a problem because bad conduct doesn't seem to disproportionately attract lawsuits.
Okay, time's up.
My question really is more about inflation. If you've got a $500,000 cap, in 10 years, that $500,000 is going to be worth about $10,000. What recourse does a person have who is in a situation where they are wanting to have a lawsuit? I mean, just the inflation factor, when it's that limited, really bothers me.
Yeah, that's a very good question, and I actually helped write one section of the Tort Reform Amendment that there's an automatic increase for inflation every 2 years, and so it's just $500,000 this year, but it gets raised by inflation every 2 years.
Okay. It may, but the fundamental problem is that local juries should be making the decisions on what the value, what the price tag on a human life is, not big government in Little Rock. It's a rigged system is what they've created. They want to cap damages. We haven't even talked about the rulemaking authority. It would be like, we haven't even, because that's where they're, as John Dingell said, let me handle the let you handle the substance, let me handle the procedure, and I'll screw you every time. They're taking over rulemaking authority in the legislature, and that's wrong.
Tony?
You have economic and non-economic damages in this bill. Could you describe what are economic damages, if they are limited, and what all can be included in economic damages when you're figuring that out?
Yes, ma'am, I sure can. Economic damages are things like medical bills and lost wages. And those are things that put, for example, Vicki Jansen, who died who was a quadriplegic for 10 years, never touched her son again. All those things put you back to even. The only thing that makes you whole, how much is it worth to be a quadriplegic for 10 years? Never walk again, never breathe on your own again, $500,000?
That wouldn't go very far.
Time's up.
So to answer your question, economic damages, as I think Mr. McCutchen said, are essentially those damages that can be objectively measured in dollars. And so this tort reform doesn't have any effect on things like medical bills or loss of income. You know, if you're depressed and you need to go see a psychiatrist, medical bills there, no effect. What it affects are what some people call non-economic or damages that are very difficult to measure, and those are things like pain. And one difficulty in measuring those things, people disagree on them, and that's the only area that's regulated by area.
Okay, we have time for one more question. Who hasn't asked one? You haven't asked one. Go ahead.
I have a question on loser pay. How does tort reform affect loser pay?
Yeah, loser pay is not addressed in this bill, but I can tell Mr. Greenberg that if there was a fair loser pay proposal, we would be totally behind. At least I would. I can't speak for everyone else, but I would be behind loser pay. But what they want to hurt the little guy. They want to make it. If Jackie filed a lawsuit and ended up losing that tough malpractice case regarding her husband, what they want to do is make Jackie think, boy, if you lose, you're going to pay. Jackie will never bring that lawsuit. It's a deterrent to.
The reason that I brought up the whole idea of separation of powers and the rulemaking ability, have the legislature write the rules, it's primarily motivated by my chief interest in legal reform. What's been my chief interest in legal reform for like the last 5-10 years? Loser pays. The only way we're going to have loser pays is if the legislature writes it, because the court can't get into policy areas. The court doesn't want to get into policy areas, but the legislature is the only body really that should be doing loser pays, because the court can't get into policy areas. We could have loser pays legislation passed. The ATLA resisted loser pays legislation when I brought it up before. I'm happy to hear that for the moment they've changed their mind.
Okay, thank you, gentlemen. Good questions from the audience. At this point, they'll have their closing statements, rebuttal, and we will start with Mr. McCutchen.
The most important thing for you to remember is that SJRA puts a arbitrary price tag on the value of human life. We conservatives believe in the value of human life, and it covers non-economic damage. It covers death, wrongful death. It covers quadriplegia. It covers brain damage. It covers Christopher Gardner, who died in a hot daycare van. By the way, Dan Sullivan, who owns that company, a friend of mine, voted against SJRA. He understood that juries should be making these decisions, and I thank Dan for that. It affects people in nursing homes. It affects quadriplegics from Ford and Firestone rollovers. But the bottom line is that SJRA undermines a meaningful trial by jury. A local jury, we believe in local control, a local jury hearing the evidence, making a decision about the value of life, and making other decisions about the conduct involved, rather than a cookie-cutter, predetermined approach, which it rigs the system for nursing homes. They want that certainty. And if they have that certainty, they're just going to do a risk-benefit analysis. That's what the Ford Pinto did. When all those people were dying and burning to death in Ford Pinto, the bean counters in the back room says it's cheaper to pay the claims than fix the problem. That's the importance of the right to trial by jury. SJR 8 is big government. Get big government control. It will. Our Constitution right now says that the Supreme Court controls procedural matters within the court. I ask you, why would Mr. Greenberg want legislators making that decision? Legislators who are farmers, teachers. That would be like me thinking that I could go in and do surgery, and it's controlled by lobbyists. If you go out there and see how much money is changing hands, how much money lobbyists are making, and who are really going to be controlling the courts. The Supreme Court now makes considered decisions over periods of months. Over what's going to happen now is Mr. Greenberg and the nursing homes are going to see that there's a case out there that they need a rule changed in. Could be a death case, could be a quadriplegic case, and they're going to go to the legislature, put pressure on legislators, and that rule is going to be changed overnight. That's the scariest part of SJR 8. It's like telling Brett Bielema, it's like telling, hey, we got a good way that you can beat Auburn next year. We're going to pay Auburn's coach Gus Malzahn. You create the rules, Brett, and you can tell Gus that he can only make $100,000. And he can't pass the ball until third down, and on first and second down, he's got to run between the tackles on the right side. We may have a shot at that point, but that's what Mr. Greenberg and the special interest elitists are trying to accomplish with rulemaking authority. It's scary because the Supreme Court is not, they are insulated from the political pressures that we see in Little Rock. Take any issue you want to. Lobbyists are winning the day in Little Rock, Arkansas. Legislators get weak in the knees when those folks come around, because it's about the money. We had one, Mr. Greenberg, Michael Morton's partner, David Norsworthy, gave Jake Files, my state senator, $90,000 of a gift, a loan, or a bribe 5 days after the Tort Reform Bill in, I believe it was 2015. That's the influences. Don't let them take your constitutional rights from you. Our Bill of Rights, our Declaration of Rights matter, and they matter now more than they ever have. We knew that back in 1874 when the railroads and government was teaming up to take our rights. Don't let them do it to us, people. Join Protect AR families, because we're standing up for the rights of the people, even if I am a trial lawyer. Even if I am. Don't let them bait and switch on you. You remember issue 3 a few years ago. You remember that issue. They sold it as an ethics bill, and what did it do? It increased term limits, and it increased legislative pay. This is what Mr. Greenberg and special interests are trying to do to you. Okay.
Greenberg.
Well, thank you again for coming today. I enjoyed debating with Joey, but I have to tell you, I'm disappointed at some of the things that he said. You know, he said I want to change the rules so that the legislature can set policy. Well, it's not just that I want to do it. That's the way it was for about 90% of Arkansas history up until about 2002. I'm disappointed when Mr. McCutchen explains that special interests are only on one side of this. In fact, special interests are on lots of sides in every debate. The ATL, trial lawyers, of course, were a huge participant in one state senator's campaign who's just been indicted, right, by the Justice Department, Senator John Woods. And so, yeah, there are certainly lots of special interests on both sides. But so that's why we have to look at the merits. I just think everybody has to follow the law, and I think we have to have separation of powers, which is a major constitutional value. Mr. McCutchen's arguing essentially for judicial supremacy, that the judiciary sets its own rules, writes its own rules, and writes policy about legal matters. Mr. McCutchen said, we haven't really talked about the rulemaking authority. Well, I talked about the rulemaking authority. It's extremely important that we have separation of powers. Now, I worry when we hear express the position that the 7th Amendment is threatened in half the country has the legislature write rules. Half the country does that. I don't think the 7th Amendment's threatened there. I think Arkansas ought to join the majority. And, you know, for a couple hundred years, judges have reduced jury verdicts in the case of unreasonable juries. I stand behind the proposition that tort reform is going to make us healthier and wealthier and better off. It's going to add more access to health care. I love Arkansas, but we all know Arkansas has severe problems with health care. I think we ought to be a lot more like Texas. And I think we ought to respect limited government. I say that Arkansas has to have limited government, not just, and balance of powers, not just the executive branch and the legislative branch, the judicial branch. I say every part of Arkansas government has to follow the law. That certainly includes juries. And the idea that juries have to follow the law, that's perfectly consistent with the 7th Amendment. I strongly support the 7th Amendment. And the thing to do, the thing to keep in mind, is the reason that we have constitutional rights. The reason that we want to have every single right of ours protected is to advance the general welfare. That's what the preamble to the Constitution says. And I would be pleased if I thought that I brought another perception to this, because I just think when we think about the welfare of everyone in Arkansas, we have to think about our future, our economic prospects, the access that we have to health care, and unfortunately, the access that some of us do not have to health care. That problem is what has been solved in other states by tort reform, and I hope that you'll agree that what I've been talking about, advancement of human welfare, more access to health care, more jobs, I hope you'll agree, and preservation of our constitutional rights, I hope you'll agree that has everything to do with advancing conservative values. Thank you.
Okay, excellent debate. Join me in thanking these gentlemen. I've moderated panels before. This is my first debate, so I hope I didn't do too much damage.
Good job, Randy.
Now you are the jury and the judge here, and we're going to take a vote and see which argument prevailed on the question of whether SJRA is conservative. Those of you who believe that Mr. Greenberg's arguments were the most persuasive, please raise your hand. Okay? And those of you who think Mr. McCutchen's arguments were the most persuasive. We have a tie. Thank you very much.
Can I call the jury?
Are you better?
Thank you so much.
Yeah, the only thing